Good afternoon, ladies and gentlemen, and welcome to the FMLA Webinar. At this time, all participants are in a listen-only mode and will remain so for the duration of the call. Please note that today's webinar is being recorded. I would now like to turn the call over to Dr. James Tachi. Dr. Tachi, you may begin.
Hello, and welcome everyone to the ACOEM webinar, Navigating Your Responsibilities as an Employer under the new and improved FMLA. My name is Dr. James Tachi, and I will be your moderator for today's program. Today's program will present the key aspects of the new obligations and regulations and present some hypothetical studies to help attendees understand the rights and obligations of employees and the employers. There is 1 hour of CME and MOC credit for this program. You should have received a verification form with today's instructions, or you can follow the link that was in the instructions. No certificates will be sent to you, but your transcript of this and other ACOEM educational programs can be viewed and printed from the ACOEM website. Members and non-members alike can both view their transcript directly from the website. Today's program will consist of about 45 minutes of lecture and questions at the end. We will address questions as time permits, and therefore we suggest that you submit your questions early for consideration, as they will likely be taken in the order that they're submitted. We are only accepting questions electronically. On the screen, you can see how to open the question box in order to submit your questions. This was also in the PDF file of the handouts that you received with the instructions for this session today. We are very fortunate today to have Peggy McCausland as our presenter. Peggy opened the law offices of Margaret A. McCausland, LLC, in June of 2006, where she focuses her practice on representing employers. Prior to opening her own law firm, Peggy was a partner at Blank Rome, LLP. She has served as an adjunct faculty at Villanova Law School since 1999. She obtained her law degree cum laude from Villanova University School of Law in 1987. In addition to other activities, she served as a staff member and then business editor of the Villanova University Law Review. Prior to attending law school, she obtained her BS from St. Joseph's University College, summa cum laude, which she attended for 7 years at night. Peggy's legal ability has been recognized by her peers in the legal profession, who have voted her a Pennsylvania super lawyer the last 5 years running. She was named as one of Pennsylvania's top 50 women super lawyers as well. She has also been recognized by members of the business community. In 2001, she was selected as one of 25 women of distinction by the Philadelphia Business Journal and the National Association of Women Business Owners. She has lectured extensively and regularly provides corporate training to assist employers in avoiding employment-related litigation. On behalf of the faculty and planning members, there are no disclosures to be made for today's presentation. So without further delay, it is my pleasure to turn our program over to Peggy McCausland. Peggy, please begin.
Thank you so much, Dr. Tachi. None of you can see the outfit, but I am wearing my super lawyer cape, and so we'll get down to it and see what we can get accomplished today. One of the things that you will see about the FMLA as we proceed is that some of the basics remained unchanged. And there are a lot of slides here. I don't expect to get through all the hypotheticals that I put together, but I thought they would be useful for you in any event, and the responses are there as well. So even if we don't get to cover them in the time we've got today, you still have some valuable information there. And just very quickly, I wanted to point out a couple of the unchanged basics. The FMLA still covers employees with 50 or more employees. There was some discussion that that might be made smaller. That did not happen, at least yet. Those employees still need to be within a 75-mile radius before the employee of an employer with 50 or more would actually have entitlement to coverage. The employee still has to have worked for a company for at least 12 months. One of the things that did get clarified is that those 12 months do not have to be consecutive. That we've known for a while, but there was some discussion about what kind of breaks we'd be looking at. We now know that if the break in service was more than 7 years, you do not have to count that in determining whether this person has met the 12 months of service requirement. There's some other pieces of that that we'll talk about in a few minutes. And another thing has not changed. The employee still has to work 1,250 hours during the previous 12-month period, and to get to that number, you would look at the Fair Labor Standards Act test for hours worked. So in other words, you would not count things like vacation. The eligibility is calculated as the day that the leave would commence. So if an employee had asked for leave in March that they didn't expect to take until April, you would count the time worked up through April in determining whether the employee had met that 1,250-hour requirement. The leave is still provided for the same basic kinds of things, for the birth of a child or care for a newborn, et cetera, the things that are laid out there on the slide. 2 new categories were added for military leave, and we're going to talk about them in more length in just a moment. Other unchanged basics, it still has to be for a serious health condition, and the definition of serious health condition did not basically change. There was some tinkering about with absence plus continuing treatment, and we're going to look at the clarifications in just a minute that were made to that part of the definition. But you still have things like inpatient care in the hospital or absence plus treatment, pregnancy, which includes time needed for prenatal care, for chronic conditions such as asthma, diabetes, etc., for permanent long-term conditions like Alzheimer's disease or a severe stroke, or for multiple treatments for non-chronic conditions. So, for example, the employee who needs time off for chemotherapy or kidney dialysis, all that is just the same as it always was. So what's new? Well, that clarification for eligibility is one of the things that they looked at, and I mentioned it a moment ago, that you don't have to look at a time that's more than 7 years past, except there's 2 exceptions to that. If that break in service resulted from fulfillment of military service obligations, or if there was a written agreement that regarding an employer's intent to rehire. So you'll often find something like that perhaps in a collective bargaining agreement. Then even if the gap was more than 7 years, it would have to be added in determining whether that employee had the 1,200 or the 12 months of service. What else got clarified on eligibility? Time that was spent serving in the National Guard or the Reserve counts towards 12 months of employment. You have to credit an employee who's returning from National Guard or Reserve duty with the hours of service that would have been worked, but for the fact that they were in that service. So that goes to that 1,250-hour piece as well as the 12 months of service piece. So assume the employee had the 12 months of service but had not, in fact, worked 1,250 hours in the prior 12 months, but the reason they didn't hit the 1,250 hours was because of National Guard duty. Well, you've got to add those hours in. And this got clarified. Some courts had already taken this position, but it's now very clear in the regs. An employee can become eligible for FMLA leave while they're already out on leave. So this is one of those areas where no good deed goes unpunished. If you had a situation where an employee had worked for you for, let's say, 7 months, and that employee is clearly not entitled to FMLA leave, but you allow the employee to go out on leave. They remain an employee. They're basically still on your books. Now, while the employee is out, they hit the 12-month anniversary, service anniversary. They are now qualified for FMLA leave. And the time that they took before cannot count towards their 12 weeks because they weren't qualified for FMLA leave during that earlier period of time. That was, in essence, a gift. So if you decide to give an employee leave before that employee is actually entitled to it by statute, it's important to recognize what you may actually be opening yourself up to. You have the right under the law to deny that leave. If you're more generous than the law requires, it could come at a cost. serious health condition. Some of the clarifying language around serious health condition is that if you're looking at a health condition that involves absence plus treatment, they have clarified that the incapacity we're looking at must be more than 3 consecutive full calendar days. There had been some case law being thrashed about prior to the new regulations, and some courts were going one way and some another. It's 3 full calendar days. They have also clarified that treatment means an in-person visit. So an employee who calls their doctor has not in fact gotten treatment. The employee has to have gone and seen the doctor. A period of incapacity or treatment due to a chronic serious health condition, now there's clarification that the employee has to certify that they visited their health care provider at least twice a year. It was not at all clear before whether they had to go to the doctor or how often. The new regulations and on the language around serious health condition have also stated that the first visit to the health care provider has to take place within 7 days of that first day of incapacity. There was no restriction at all before on how soon or late the employee had to see the doctor. And if we're talking about a situation where it's got to be 2 or more visits, then that second visit has to take place within 30 days of the date that the incapacity began. These are not magic bullets for employers, but they at least add a little bit more structure than employers had before in determining whether an employee actually qualified for FMLA. And when additional treatment visits or regimens are necessary, it gets to be determined by the healthcare provider, not by the employee. So you have a right to information from a healthcare provider that makes it clear that the healthcare provider is saying that additional treatment or visits are necessary, not just the employee saying, well, I think I need to go to the doctor again. Information has always been a struggle under the FMLA. There's been a real tension sometimes between the information that an employer needs and is entitled to in order to determine whether an employee is entitled to leave, and things like HIPAA, the privacy concerns, not wanting to run afoul of the other statutes, maybe finding out more than you wish you knew because now you've created an ADA problem. So there's been some clarification given to employers about what they can ask for, how, when. There are new forms that have been provided that have called for much more information in the healthcare provider certificate than in previously, and you have a different one for the serious health condition of the employee versus the serious health condition of the family member. There's a different form for when someone's asking to go out on one of the military leaves that we're talking about as opposed to more generalized FMLA. So when you get those forms, what are you allowed to do with them? Well, you may not ask for more information than the form calls for, but you do have a right to clarification about the information that the form calls for if, in fact, it's insufficient or indecipherable, or you have reason to think perhaps that it's not authentic. Now, what can you do? You have to give the employee at least 7 days to cure the problem on their own, to go back to their physician and get this information. Let's assume they don't. Now what can you do? Your own healthcare provider or a human resources professional, or if your company has a leave administrator or some other management official, anybody other than the employee's direct supervisor, that cannot be the management official, may then contact the employee's healthcare provider and ask for clarification of the information provided. Or let's say there were gaps, there were lines that weren't filled in, you can ask for it to be completed or to be clarified. You just can't ask for more than that form would call for its own. And if an employee, sometimes the healthcare provider's response is, well, I need HIPAA authorization. If the employee refuses to provide that HIPAA authorization, then you have a right to deny the FMLA request if that form didn't give you the information you needed to make an intelligent decision about FMLA. You can use medical information that you obtain under the Americans with Disabilities Act or paid leave programs in concluding whether or not the person is entitled to family medical leave. Sometimes you get things in these sort of silos. You're dealing with one issue and you get some information. Now you're dealing with a separate issue. You're allowed to consider that. And that cannot be held against you in deciding whether someone's entitled to FMLA. Now, there's some new regulations about what notice the employee has to give. It's still far from ideal for employers, but it's a little better. If the leave is unforeseeable, the employee must provide notice the same day or the next day unless there was some special circumstances. Obviously, if the employee is in an automobile accident and they're lying in the emergency room and they're incoherent, that's not going to apply. But absent something like that, the employee now has a little bit more structure surrounding what they have to tell you and when. And you have a right as an employer to delay the approval of the leave for the time that notice should have been provided but wasn't. That doesn't mean you're going to be able to deny it altogether, but let's say they didn't get you the information for 5 days instead of 2, and there was no special circumstances, then you don't have to start the leave until the 5 days. You could start it sooner if you want to, but you wouldn't have to. If you denied the employee the right to take the leave in that interim period because the employee had not in fact provided you the notice that he or she should have, then you would be able to subject that employee to discipline for an unapproved absence consistent with your attendance policies. A lot of employers, I think, almost gave up bothering to have attendance policies. They got so frustrated by the Family Medical Leave Act and sort of threw up their hands and thought, what's the point of having these policies when the FMLA pretty much guarantees employees time no matter what? Well, this is a reason to still have those policies. Even though you can never discipline an employee for taking approved and correct FMLA time, sometimes the absence isn't going to be covered by it, and that's why it's still worth having certain policies surrounding your attendance issues. The employee has to now, it's clear, I think this was always the case, but it was sometimes ignored or not as clear as it is now, but the employee needs to provide sufficient detail so that you can determine if this absence in fact qualifies for FMLA. In other words, the employee doesn't get to just call in sick and suddenly they're protected by FMLA. You have a right to require the employee to follow your usual and customary notice and procedural requirements for requesting leave. This was something that definitely was at best a gray area before, and but it's been clarified. So if you've got call-in procedures, just because it's FMLA doesn't mean the employee doesn't have to follow those call-in procedures. Obviously, you're not going to subject an FMLA employee to more stringent procedures than someone else, but as long as you're applying these things consistently, the fact that it's FMLA leave doesn't make it somehow exempt from following your normal requirements. And if I've got a condition, let's say like asthma, and I've notified you of this condition and therefore I will sometimes be taking intermittent leave for my asthma. If I'm taking an FMLA day for the asthma, I need to let you know that, not just this, you know, I won't be in today, I'm sick, and somehow you're supposed to have a crystal ball and have figured out that this was in fact for my asthma. Scheduling and tracking intermittent leave, this was supposed to be an improvement that would help employers. Really, I find it of little use, but they did add the phrase reasonable effort. basically said that if an employee is taking intermittent leave, they have to make a reasonable effort to schedule their treatment so as not to disrupt unduly the employer's operations. An employer's always had the right to sort of hope that an employee did that. I don't know what help the reasonable effort language is going to make, but where something like that could be useful is a situation where someone has doctor's appointments that they need to go to for their health condition, or maybe for an aging parent, let's say. And you have a right to expect them to make those appointments after work hours, if in fact it's possible to do that, and them taking the time off during work hours would unduly disrupt your operations. These are all things that we'll probably fight over the next 10 years, the way we just did before the change in regulations, as courts now play with, well, what does unduly disrupt mean, or what does reasonable effort mean? And we'll start to see some examples of what met the test and what didn't. For now, that's the language you have to work with. And you have the right as an employer, as you did before, to transfer an employee to an alternate position if they're going to be on intermittent leave, but only in cases of planned medical treatment. So, for example, the kind of thing I just mentioned, where an employee is going to have standing doctor's appointments, and you kind of know that every week they're going to need to be out for this treatment or whatever. Under those circumstances, you would be allowed to move them to a position that better accommodated their need to be out. If it's something like the asthma, where there's just a sporadic attack every once in a while, that you wouldn't have the right to move the employee, because this is not a scheduled or planned medical treatment that's interfering with their ability to come to work. Calculating increments, this isn't a big change, but more of a clarification. You can track FMLA leave in increments. You're not required to track FMLA increments in anything smaller than an hour, unless you track other absences in increments smaller than an hour. Then you would have to do the same for FMLA. You cannot charge an employee FMLA time for time worked. I think that's always been the case, but this, again, it was sort of clarified. So, for example, if an employee said they were going to take the morning off to go to the doctor's, and then they came in at 10, you couldn't charge them the whole half day. You could only charge them for the 9 to 10 hour that they actually missed, as opposed to the whole morning. And you have to provide an employee with the amount of leave that he or she has taken to date if the employee requests that, and that determination couldn't be made when the designation notice was provided, because that's another new piece. We now, when an employee requests leave, you'll give them their notice of rights and responsibilities form, and then they will provide the healthcare provider certificate that's appropriate to the type of absence they're taking. Then you will provide a designation form, and that designation form will indicate whether you are designating an FMLA or not. If at that point in time you weren't able to tell how much time a person had taken to date, and they later asked for it, then you need to do that calculation for them. They can only make that kind of request once in every 30-day period, and only if they actually took some leave in that 30-day period. There's some clarification on substitution of paid leave. Prior to these changes, depending on whether the paid leave was vacation or sick time or disability, there were different guidelines and provisions on how you looked at these things. Now it's all the same. You have a right as an employer to require substitution of paid leave for FMLA leave if, in fact, that's the way you want to do it. Again, you don't have to do it that way, but you have the right to. But all of that kind of paid leave will basically be treated the same. And if, in fact, you had requirements for paid leave, you have the requirement that paid leave will always substitute for FMLA, and you've got certain requirements that attach to paid leave, there's sort of a question about, well, could you then deny FMLA leave if they had not fulfilled the normal terms and conditions of the paid leave? I think that answer is no. It wasn't actually addressed, but I think it's no, and certainly my recommendation would be never deny an employee unpaid FMLA because they didn't meet the requirements for taking paid leave, even if you require them to substitute paid for unpaid. Overtime, they clarified, failure to work normally scheduled overtime hours will in fact count as FMLA leave. So if you had a workplace where people worked 10 hours a day instead of 8 hours a day, and that was regularly scheduled, then they've used 10 hours of FMLA when they didn't come in on a particular day. This was not supposed to be a change in policy, but a clarification of what the Department of Labor believed was always the case. Light duty times, again, I think these are more clarifications than anything new. Time spent working on light duty while recovering from a serious health care condition may not be counted towards an employee's FMLA entitlement, and it can't interfere with their reinstatement rights. So, for example, when your workers' comp carrier is stressing that they want that employee back at work, even light duty, and you put the employee back light duty, that's fine, but that's not FMLA time anymore, and you can't be deducting from their bank. And while they're on light duty, their right to have their job restored is kind of held open for at least 12 months. If the light duty assignment was finite length, then reinstatement at the end of the light duty assignment. Fitness for duty. You can require a fitness for duty report to address the essential functions of the job, and as long as the employee is informed of the requirement, and if you provide a list of essential functions to the employee when the leave was originally designated. So you want to think that through at the beginning so that you can get that fitness for duty entitlement at the end. And you can require an employee who is on intermittent leave to submit fitness for duty certificates as often as every 30 days now if leave is taken during that time period. If you've got reasonable safety concerns, for example, let's say a roofer who experienced a panic attack, or you have a practice or policy that's uniformly applied. What you never want to be doing is applying to people on FMLA requirements that you don't apply to people on other forms of leave. Awards and bonuses, they fixed this for us. For a while there, if you had a perfect attendance award bonus, an employee took FMLA, they still got the bonus. That's not so anymore. As long as this award or bonus is based on the achievement of a specific goal, like attendance or the product sold, and the employee fails to meet that, and the reason they failed was they were on FMLA, well, so be it. They didn't meet the goal, and that's okay. You don't have to provide the bonus. But the other caveat, again, is as long as other employees that were on a non-FMLA leave also didn't get the bonus. So you just never want to be singling out FMLA folks. So those are kind of the changes to what we already had. Now, in addition to that, we have these new military leave provisions, and there are two different types of them. One of them you will see referred to as qualifying exigency leave. The other is military caregiver leave. While they both tie into military duty or families on military duty, they're really very different in their approaches and what it is they're covering. So we're going to focus first on the qualifying exigency leave. This entitles an employee to up to 12 weeks of leave in the employer's established 12-month period. So it's really just a new type or a new category, let's say, of the ordinary FMLA leave to which an employee was always entitled. All the conditions are the same, the 12-month service, the 1,250 hours, everything's the same. It's just one more category. It's not an additional 12 weeks, just a new basis for the regular 12 weeks. Just like the regular, it can be taken on an intermittent or reduced schedule basis. Now, who is it available to? Well, it's available to the spouse, the child, the parent of a member of the military, of the National Guard or the retired military, who, if that person, if that family member is on active duty and has been notified of an impending call or an order, has been ordered to active duty in the armed forces in support of what's being referred to as a contingency operation. The definition of that is vague, but think Iraq, Afghanistan. This is limited to federal call. So if a state governor called up the National Guard, that would not trigger this provision. Now, you'll notice that it says it's available to the spouse, child, or parent. So if you're the parent of a child who is a member of the National Guard or Reserves, or the retired military, and who's on active duty, it doesn't matter that that child is 35. When we think of our ordinary FMLA leave, it's got to be a minor child, or the child has to be incapable of self-care. Not the case here. So there's no limit on the age of this child. Now, what are the rights of the employer and the employee under this? The employer can require that the request be supported by this certificate, that the certification form that's been created. You can't request additional information, and you can get verification from third parties regarding various meetings and such that are covered for this. For the first request, you can request verification from DOD that the Department of Defense that the covered member is actually on active duty status. And what are the reasons? Well, if there was a short notice deployment, so for example, the family member got notified that he or she's going to be deployed in less than 7 days, then your employee could take leave for up to 7 days for basically any reason connected with that deployment. Military events, what are those? Well, if your employee wanted to attend an official ceremony or program or event that's sponsored by the military, or attend family support and assistance programs, information programs sponsored by the military, child care and school activities. It's to arrange for child care. So it's not that your employee could suddenly take off 12 weeks to provide child care, but they could take off the time they needed to help their daughter or son or their spouse arrange for child care. Now, and also they could be the one providing child care, but that's on an emergent, immediate basis, not the whole necessarily 12 weeks. To attend to certain school functions. This would not be the school play, but disciplinary meetings or parent-teachers conferences, or to arrange for enrollment or transfer. To help with financial and legal arrangements, such as preparing or executing a will or power of attorney, et cetera, the things that you see there on the slide. For R&R, this person's spouse is on active military duty, and they're entitled to up to 5 days to spend with the covered family member while that person's on leave during that deployment. To attend counseling, if the need for that counseling arises from the active military duty or the call to duty. Post-deployment activities, ceremonies that are incident to the person's return up to 90 days following that family member's termination of active duty status. To attend activities arising from the death of the service member, even if that's beyond the 90-day limitation. And any other activities that are agreed upon by the employer and the employee. So that's 12 weeks of leave that this employee would be entitled to take for the reasons that we just went through if they otherwise qualified for family medical leave. Now, there's a whole separate category. This one they refer to as military caregiver leave. This is leave to provide care for a covered service member who is a current member of the Armed Forces, National Guard, or Reserves. The other category didn't actually cover members of the Armed Forces. It was National Guard, Reserves, retired military. And that's because the thought was those folks who are actually on active duty, they've already got some of those support systems in place for the things that we just went through. This one's different. This is my active duty Armed Forces spouse gets injured, or my National Guard spouse, parent, child. They suffer a serious injury or illness incurred in the line of duty while on active duty. And as a result, that person becomes medically unfit to perform his or her duties. This gets triggered. Now, they're undergoing medical treatment or recuperation or therapy. Can be on an outpatient status or temporary disability retired list. So this gets triggered. Now, this covers a broader category of people too, because in addition to covering a service member's spouse, child, or parent, regardless of the child's age, as in the last category, this also would, if my employee is the next of kin of one of these military service people, then they're entitled to this leave, assuming the other things kick into place. And how do we know who a next of kin is? Well, the service member may identify who that next of kin was. So, they didn't have a spouse, a child, or a parent, but they designated a grandparent. If no designation was made, then there's this list in order of preference. The military would look at blood relatives who have been granted legal custody by court or statute. They would look at brothers or sisters, grandparents. They would look at aunts and uncles, first cousins. Now, something that's interesting about this is if let's say they went to the brothers, sisters category, and you have an employee who is the person's brother, but the person also has a sister. It doesn't matter if both of those people are caring for this person. You've got to give your employee the leave. Same thing with aunts and uncles. So if they're in the same line of category, they're entitled to the leave, even if there's someone else equally available to provide it. What can you do? Well, you can require reasonable documentation of the familial relationship. You can require the certification form that the Department of Labor has now in place for these. You're allowed to seek clarification. You can seek second or third opinions. Leave can be taken on an intermittent or reduced schedule basis, just as with all other FMLA. Now, this is there's a 12-month period, but it's 26 weeks of leave, and this is a very convoluted calculation under certain circumstances. Here, no matter what you as an employer have structured as your 12-month period, let's say you said it was calendar year, or you said it was anniversary year, regardless of that, this entitlement begins with the first day of the military caregiver leave. That's what triggers the beginning of the 12-month period for purposes of this 26 weeks. And it cannot be carried over past that 12 months. If it's not used, it's lost. It applies on a per covered service member per injury basis, however. So it could wind up getting triggered with a second injury of the same military family member. So that kind of takes us through the basic changes and additions that came along as a result of the January 2009 changes to the regulations. So with that, I thought we'd work through some hypotheticals that might clarify some of the points we've just gone through. So hypothetical number one, we have an employee who works for an employer for 6 months. They leave for 5 years, and they return for 4 months when they're called for active duty in the reserve. The employee is on active duty for a year, returns, and 1 month later asks for FMLA to care for their mother who is incapable of self-care. The supervisor wants to deny the leave because the employee, I'm sorry, I just got it. I'm sorry, because the employee has not worked 1,250 hours in the prior 12 months. What do we have here? Sorry. There we go. And what would be the recommended action in this situation? Well, I would say the employer here needs to provide that employee with the appropriate forms. One is the notice of eligibility and rights and responsibilities, indicating that that employee is eligible, because the time that was spent in the reserves counts towards that 12 months of service and counts towards the 1,250 hours. And break in service previously is irrelevant to all of this. Then you would also provide the employee with this form WH-380, which is a certification for a family member's serious health condition. And then assuming that the information you got is sufficient, you're going to provide that employee with a completed designation notice granting the request for the leave. Hypothetical 2, we have an employee who requests 6 weeks of medical leave for surgery after 11 months of employment. Short-term disability is granted, during which time the employee remains on the payroll. At the conclusion of the short-term disability, the employee asks for 12 weeks of FMLA leave to be with his father, who's been diagnosed with cancer and lives alone in another state. The supervisor is inclined to deny the request, or alternatively, she wants to grant only an additional 6 weeks because the employee had already taken 6 weeks of leave. We covered this at the beginning. You need to provide this employee with notice of eligibility and the rights and responsibilities form indicating that the employee is eligible for FMLA, and give them the certification for this time for the serious health condition of a family member, because the new regulations make it clear that that time that was spent on STD counted towards the 12 months of service. The employee became eligible for FMLA while on leave. And assuming that that documentation comes back appropriately, then you have to give the employee approximately 10 weeks of leave, because the FMLA leave couldn't begin before that employee was eligible, so only 2 weeks of that prior time could actually count towards FMLA time. After 6 months of employment, an employee advises she's pregnant, will need FMLA leave after she's been there 12 months. The supervisor had given the employee written reprimand shortly before her announcement. Now the supervisor wants to terminate the employee before she reaches her first anniversary and becomes eligible for FMLA. My recommendation here is you proceed with extreme caution. Do not terminate that employee unless you have new grounds unrelated to the leave notice. Even before the regs have been changed, courts have held that an employee like this could bring a retaliation claim under the FMLA, because FMLA itself requires that an employee give as much notice as possible. That's exactly what this employee did. She let the employer know as early as she could that she was going to need this leave. Therefore, any disciplinary action that's taken after that notice is likely to look retaliatory, and given that this supervisor had been unhappy with the performance before the notice, now it looks like, well, it's the notice that's triggered this desire to terminate. Hypothetical 4, employee underwent surgery related to coronary artery disease. She returns and the supervisor is dissatisfied with her performance, gives her a written warning about performance issues in the weeks leading up to the leave. The employee is told by her doctors that she may need to have additional surgery, and she mentions that to her supervisor. Supervisor wishes to terminate for performance problems before the employee formally requests FMLA leave. This is another one where you want to proceed with extreme caution. Courts have held that an employee does not have to submit a formal request for FMLA in order to be protected by the leave. We talked earlier about they can't just call in and say sick day. They have to give you some notice, some information that suggests it's FMLA, but that's what this employee did. They just didn't say it was definite, but it was very clear from that information that it involved a serious health condition. So once that was mentioned to that the supervisor that the surgery might be needed, that's sufficient notice to protect an employee from retaliation from an employer for FMLA leave. Employee was granted 30 weeks of medical leave after a cancer diagnosis. Company never advised the employee that the leave was for FMLA. Employee is now asked for FMLA leave, and the supervisor wants to deny the request because the employee had already taken more than 12 weeks of FMLA at the time. I would say you analyze this situation to determine whether or not the company's failure to provide the notice prejudiced the employee in any way. This was basically the Ragsdale case of some years ago, and it's now been clarified in the new regs that the employer's failure to designate properly as FMLA leave is not fatal, but it can be fatal if the failure to designate impacted the employee in some way. So, for example, if we were dealing with a situation where an employee had elective surgery. Now, we're not talking about cosmetic surgery here. Surgery for a genuine and serious health condition, but they didn't have to take it now. The doctor said no harm if you wait 6 months. And they took it now. And they took it now because they thought they had FMLA leave coming because you had failed to designate old leave. If under those circumstances you tried to deny the leave, that would be fatal. So, if you always try to get it right, always try to do the designation as appropriate. If you fail to do the designation appropriately, then analyze to see is there prejudice in your having done so. Employee calls in to the proper person in a timely fashion, says they won't be in for the next 3 days because they're sick. Supervisor wants to issue a final warning to the employee because the number of days that he's taken off has exceeded the number of permissible absences not covered by FMLA. Under the new regulations, the employer could deny FMLA leave to this employee because they failed to provide sufficient information to suggest FMLA leave, as long as the employer has provided kind of proper notice in a handbook or somewhere else about what the rules are and is acting in a consistent fashion so that they're not singling this employee out. But you always want to proceed with caution. Now, there are numerous other hypotheticals here, but they all, as these do, have the explanation, the recommended action. So rather than continue through them, I wanted to leave time for questions from you folks. Jim, do you know if we had any questions from anybody?
We do have a few questions, and we can address those first, and then we'll leave some time for the we'll do the MOC questions first, and then we'll leave some time for our submitted questions as well.
Okay.
So for our first MOC questions, and this is where folks in the audience want to start paying particular attention. True or false to Peggy? In determining whether an employee has the necessary 12 months of service and has worked the necessary 1,250 hours in the previous 12-month period, you must count all service to the company no matter how long ago, and may begin counting the 1,250 hours on the day the employee asks for the leave. True or false?
And I now give you the
correct. You can then walk us through the answer, true or false, and then explain the rationale.
Right. And the answer here would be false. You would only need to count the service going back 7 years, and the 1,250 hours would be calculated as of the date that the FMLA leave actually started.
Very good. Our second MOC and CME question, again, true or false, for an employee whose serious health condition involves absence plus treatment, the employee may qualify for FMLA even if he or she has only spoken to the doctor over the telephone.
And the answer to this would also be false, because under the new regulations, treatment means an in-person visit.
Very good. And for our third MOC and CME question, again, true or false, the amount of leave available to an employee who qualifies for military exigency leave or military caregiver leave is different. And
the answer to this one is true, because under the exigency leave, the employee may take 12 weeks of military leave in the employer's normal 12-month period. Under the military caregiver leave, they get 26 weeks of military leave, and the 12-month period beginning with the first date on which the person took the leave.
Okie doke. We'll now move on to the Q&A session with submitted questions. The first one is, if a business has an incentive program in place for its employees based on products sold, and one employee is out of work as a result of FMLA covered absence, can the employee be denied participation in that incentive program altogether, or would the employee still participate in the incentive program but perhaps not win because of the FMLA covered absence?
As I read the regs now, and what we don't have yet are new court cases fleshing these things out as they get challenged. That'll come over time. But I would say that as read now, it appears that you could deny the employee whatever the prize was, the result of the incentive program based on products sold. What I think would probably be a smarter way to do it, because usually what happens is employers take the more stringent view and then it gets challenged and then it works its way through the courts, is perhaps do it on a pro rata basis, so that you kind of calculated what the goal would have been on the time they actually were there to work. But as I read the regs at this time, I think it could in fact be, they're just not entitled to the incentive because they didn't meet the established goal, and that goal was measurable, sort of like perfect attendance.
Okay, thank you very much. Another submitted question. If an active reservist is called up for deployment and is given 5 days notice to prepare for deployment, would his or her spouse be able to take time under the current FMLA provisions to help with family preparations in advance of that deployment, and what special forms are required of the spouse by the employer?
And the answer to that would be yes, because that would be under the 7 days. So we'd be looking at the exigency leave, which anything under 7 days notice gets triggered. Ask me, or would you read again for me, Jim, the beginning? Was it an active duty military?
The way the question is written, if an active reservist is the way it was written.
Okay, so yes, because the person's in the reserve and not regular military, because then that came in under the 7 days, then as long as it was for, they can take the leave for any reason, given that it was under 7 days. So, to help with household issues or whatever, the answer would be yes.
Okie doke. Thanks very much. There's a third question. How do the new provisions regarding the military differ from the previous provisions? And this gets kind of a long, open-ended question, so you may not have time to give a complete answer.
Right. Well, they certainly give us additional reasons that an employee is going to be able to take leave. They cover different categories of family members, because as we discussed, we have no age limit, for example, on the age of the child who's the family member. Under the military caregiver piece, we also throw in next of kin, so it's a broader sort of group of people that are going to be entitled to this. When we're looking at the military caregiver leave, we're looking at 26 weeks rather than 12, and we're looking at a different 12-month period. So there are a number of ways in which the military leave piece of all of this is different than it would be under the more traditional FMLA piece.
All right, Peg, thanks very much. Those are the submitted questions. I would call the listeners' attention to their screen now, and I believe folks are answering. There is a post-seminar poll that's being conducted, and I would encourage people to participate because it helps ACOEM continuously improve the quality of these webinars. I want to thank everyone for their attendance. I'd also like to thank Peggy for not only her participation but her guidance on this very complicated issue. If people in our audience found this program informative, then they might also be interested in a similar program that was conducted by Ms. McCausland in December of 2008 on the Americans with Disabilities Act and the ADAAA, or the Americans with Disabilities Act Amendments Act. That program is available on the ACOEM website. This concludes today's program. Folks may disconnect as they see fit, and thanks again to everyone for joining us today.
Thank you very much, ladies and